Caleb Reese, the Firearms Policy Coalition, the Second Amendment Foundation, Louisiana Shooting Association, and Emily Naquin sued the Bureau of Alcohol, Tobacco, Firearms, and Explosives, their director, Stephen Dettelbach, and the acting U.S. Attorney General James R. McHenry III, claiming that federal law and regulations violate their rights protected by the Second Amendment. Appellants filed suit in the district court against the Bureau of Alcohol, Tobacco, Firearms, and Explosives, its director, and the Attorney General of the United States, challenging the constitutionality of 18 U.S.C. sections 922b1 and c1 and their attendant regulations, including 27 CFR sections 478.99b, 478.112a, and 478.96b. These provisions, in effect, prohibit federal firearms licensees from selling or delivering handguns to adults under the age of 21. Appellants contend that the federal laws unconstitutionally infringe on their right to keep and bear arms under the Second Amendment and deny them the equal protection under the Due Process Clause of the Fifth Amendment. The Fifth Amendment doesn't have an equal protection clause, and I don't see how the Due Process Clause establishes one. The case continues with the actions of Congress. Congress enacted the Omnibus Crime Control and Safe Streets Act in 1968, and inter alia prohibited FFLs from selling certain firearms to certain purchasers based on the purchaser's age. The first challenge provision states, "It shall be unlawful for any licensed importer, licensed manufacturer, licensed dealer, or licensed collector to sell or deliver any firearm or ammunition to any individual who the licensee knows or has a reasonable cause to believe is less than 18 years old, and if the firearm or ammunition is other than a shotgun or rifle, or ammunition for a shotgun or rifle, to any individual who the licensee knows or has a reasonable cause to believe is less than 21 years of age." Now, the Omnibus Crime Control and Safe Streets Act establishes two sets of restrictions based on age. First, it prohibits licensed dealers from selling firearms to anyone under the age of 18. Second, it prohibits the sale of any firearm other than a shotgun or rifle to anyone under the age of 21. The law goes on to state, additionally, Section 922c1 prohibits FFLs from selling such a firearm to a person who does not appear in person at the licensee's business premises, absent a sworn statement that they are 21 years or more of age. So if you purchase a firearm from a licensed dealer, you're supposed to provide a sworn statement that you're at least 21 years of age. Now, based on this law, the ATF promulgated regulations. ATF implemented regulations prohibiting the sale of firearms other than a shotgun or rifle to adults under 21. 27 CFR 478.99b, for instance, states in part, "A licensed importer, licensed manufacturer, licensed dealer, or licensed collector shall not sell, deliver any firearm or ammunition other than a shotgun or rifle or ammunition for a shotgun or rifle to any individual who the importer, manufacturer, dealer, or collector knows or has a reasonable cause to believe is less than 21 years of age." Now, between the law and the regulation, adults under the age of 21 were denied their right to purchase a handgun. As a result, 18 to 21-year-olds may not purchase handguns from FFLs. The Act and regulations do nothing to prohibit 18 to 20-year-olds from owning, possessing, or carrying handguns, nor does it prohibit them from buying handguns in an unlicensed private market or receiving handguns as a gift. That's an interesting loophole. Someone between the ages of 18 and 21 can own a handgun, but cannot buy one except on the private market. Since it is a federal crime to purchase a firearm for someone else, known as a straw purchase, that leaves people who can legally own a firearm in quite a conundrum. How can you own a firearm unless you purchase it? And since you can't purchase one from a licensed dealer, you're forced to do so from an unlicensed one, which I doubt was ATF's plan when they proposed this rule. Appellants allege that this handgun ban is inconsistent with our nation's history of firearm regulation and thus unconstitutionally infringes on their Second Amendment right to keep and bear arms. Telling someone they can own a firearm, just not purchase one, seems to infringe on a person's right to keep and bear arms.